Good evening, everyone. I'm Anjali Sinha, and I welcome you all to the fifth episode of Arbitration Plus webinar series conducted by Society of Arbitration Law, HNLU. Today, we have with us Mr. Madhav Kumar. Mr. Madhav Kumar has an experience of 5 years and is currently a consultant in arbitration and ADR. He is a graduate from Nirma University and has done his LLM from University of Hong Kong in 2017. He also has an experience of 2 years working as a counsel for CTEC Hong Kong. We welcome you, sir, to this session, and we look forward to an amazing session ahead.
Thank you so much, Anjali. It's a pleasure to be here.
Right. So as today's topic is mediation, arbitration, mediation, connecting the dots between mediation and arbitration. So it would be great if you could tell us why, what these multi-tier arbitration clauses are all about, and why is it put in arbitration agreements in general?
Okay, so just to start with, I just want to clarify that Arb-Med-Arb is probably not the same thing as a multi-tiered clause.
Yeah.
Arb-Med-Arb is a completely different process in itself. A multi-tiered clause is a clause which you have written either in a contract or separately as an arbitration agreement. Now, just to give some context, I would like to probably begin with giving a simple idea of what an Arb-Med-Arb process is. So for that, we need to probably know what arbitration is and mediation is, see what are the similarities, and then see what are the differences, and find out how that would work. So now coming to the similarities of arbitration and mediation. So one, I guess most of you, if not all, would know that both arbitration and mediation is a private mode of settling dispute, which is basically an alternative to going to the courts to resolve a dispute. And secondly, both arbitration and mediation, you have a third party who is independent, who will be assisting in resolving a dispute. And thirdly, if you look into it, both arbitration and mediation hinge on the concept of party autonomy.
Right.
Now, this is very important. So I was told that we have students from first year and second year, and I think it would be important to note that arbitration is only validated or given effect to once you have an agreement between two parties. So it has to be documented though. For arbitration, so you would either have an arbitration agreement where if me and say Anjali are disputing parties, we have agreed in an agreement that we would have an arbitration to resolve our dispute. Or we could have a contract, which we have probably concluded long before, and include a clause within that, stating that if there is a dispute within this contract, then we invoke this clause to start an arbitration. So that becomes an agreement. So I won't get into the intricacies of severability and other concepts, but this is just the basic cornerstone of arbitration where parties' agreement is very important. Same as with mediation. Mediation is when parties agree that they would have their dispute settled through mediation using a mediator or an independent third party. So now that said, there is also this concept of statutory. So mandatorily, you have to probably go for arbitration mandatorily because of a statutory requirement. We see that in many states in India. There are a few states that make it mandatory to arbitrate if you have a dispute against the government. So if you have government contracts, if you are a private company and you have a contract with the government, you would probably have to include an arbitration clause within it. Or if not, you would probably have to go to arbitration because it's statutorily required. It's the same in the US as well. The Federal Arbitration Act does statutorily provide that you should go for arbitration when it comes to employment matters. So but it's very rare. It's probably in only a few jurisdictions that you would see it. And most of the times you would see that parties' agreement would generally invoke arbitration. Now, when you go to mediation, mediation is slightly different because yes, you don't need a clause for mediation. You can have a clause. It's not necessarily need a clause. Me and you, if we have a dispute, we can just go into mediation by just agreeing, let's just mediate the dispute. But in a few jurisdictions, there is statutory requirement as well. So mandatorily. So for Hong Kong, for that instance, there is something called the Practice Direction 31, where every civil matters, the parties should start with mediation. They should try mediation and then only go to the courts. If the court finds out that the parties did not try to mediate the dispute before they came to the courts can have adverse costs, can basically provide orders saying that the parties have to pay a cost because they didn't try to settle the dispute before they came to the court. And just now you are burdening the court with that. So the same thing is also there in Singapore as well. So that's the third one, parties agreement. Fourth one I would like to talk about is confidentiality. So arbitration and mediation both ensure confidentiality. However, I would say that for mediation, it is probably it's more stringent because of this concept called without prejudice. I'm not sure if, well, most likely not many of you would have heard of it. So the without prejudice rule basically states that if anything is disclosed during a mediation, that will not be used as an evidence, so that cannot be admitted as an evidence in the court or in a subsequent arbitration. So as somebody, so let's say I'll take an example. So me and Anjali, me and you, we have a motor vehicle accident. And probably you had parked your car at the place where you're not allowed to park. And I bumped into your car. Now we decide to settle this dispute through mediation. Now we go to mediation, and then knowing that the entire process is confidential, would say that actually I was looking at my phone and I did not see Anjali's car right in front of me. And I was basically blaming you for the accident rather than blaming myself. But this is something that I said with confidence because I knew this was confidential. Now if you go to court afterwards, Anjali cannot use this statement that I just stated against me. So it should not prejudice me in the court or in an arbitration later on. So these are the similarities. Now let's go to the differences. Now the difference is, one, arbitration is an adjudicative process.
Right.
So what I mean by adjudicative is you have somebody deciding on a dispute. You will have an award and a decision, and that would be based on reasonings or based on some judgment. While in mediation, it's a completely non-adjudicative process. And it's where the mediator would only try for the parties to come to a resolution rather than the mediator himself giving a solution. Now, the second one is that arbitration mirrors litigation mostly.
Yeah.
While mediation is more of a facilitated negotiation. So negotiation is between two parties. When you have a third party who's facilitating that negotiation, it becomes mediation. Now, when I talk about these two, so then comes the third point, which would say that arbitration is completely contentious. So you would have a winner and a loser. And you would have two counsels fighting, just making sure that the clients win. While in mediation, it's not contentious. They try to come to an amicable settlement. And it is more of a win-win situation. So where I'm getting to is that even though both are ADRs, like alternative dispute resolution, and both are private dispute resolution mechanisms, they are very different. And hence, when you combine them, it becomes a hybrid process.
Right.
That's when Arb-Med-Arb. So you're basically having two different processes combined together, having different results altogether. So this is Arb-Med-Arb. Now coming to your specific question as to how you can construct a clause. So for that, let me first state that an Arb-Med-Arb process is effected or validated in two ways. So one, like you mentioned, it could be a multi-tiered clause. So a multi-tiered clause is where in a clause you would mention that before we go to arbitration, so it's a level. So you have different levels, multi-tier, different tiers. So before we go to arbitration, we first try to negotiate the matter. If we can't negotiate within a particular time, we'll try to mediate. If mediation does not work as well, then we go for arbitration. So that becomes a multi-tiered clause, and that is very common. And you see a lot of clauses that are drafted in such a way that they look into all procedures to settle their disputes. And the second way is that you would probably have a clause which would adopt a particular set of institutional rules. So it could be CTAC, it could be HKIAC, or that is the Hong Kong International Arbitration Center, or the Singapore International Arbitration Center. And
I'm sorry, sir.
No problem. Yes. So when you adopt the clause, when you adopt the set of institutional rules, it's already provided in those rules that a procedure as to how an Arb-Med-Arb process works. So CTAC has it. So CTAC arbitration rules, Article 47 clearly states that conciliation, so they call it conciliation rather than mediation. Conciliation can be combined with arbitration, and there is this procedure that they set. HKIC just included the same in their 2018 administered rules. And the Singapore International Arbitration Center introduced the same in 2016. So there is something called the Arb-Med-Arb Protocol, which is adopted by the Singapore International Arbitration Center and the Singapore International Mediation Center. So now how you construct. So if I can just share my screen for this one.
Yeah,
I could just give an example. Okay. It says I've been disabled to share my screen.
Sorry, is it?
Let me try once again. Yeah, now it's fine.
Cool.
Okay, now. Yeah, are you able to see it?
Yeah, yes, sir.
Yeah, so this is something that I extracted from the Indian Institute of Arbitration and Mediation. And they have something called the suggested Arb-Med-Arb Clause. If you can read it, it says any dispute, difference, or controversy arising out of or in connection with this contract, including any question regarding its existence, operation, termination, validity, or breach thereof, shall be referred to and finally resolved by arbitration as per the Arbitration and Conciliation Act 1976 and using the set of rules. So this is a clear example of how an arbitration clause is drafted in a contract. Now the difference though is that eventually you would also have something written that it is further agreed that following the commencement of arbitration, the parties will attempt in good faith to resolve such dispute, difference, or controversy as per the IIAM Arb-Med-Arb procedure for the time being in force. Any settlement reached in the course of mediation shall be referred to the arbitral tribunal appointed by IIAM and may be made a consent award on agreed terms. So this is something that the IIAM provides. There is the similar clause for the SAIAC as well. It's very similar. It's pretty much copy paste. I think IIAM must have copied from SAIAC or the other way. And for HKIAC, you have Article 13.8, which allows use of alternative means of dispute settlement, which is example of Arb-Med-Arb. And eventually, so yeah, I think, so these three institutions already provide, and these are clauses which provide an Arb-Med-Arb scenario. With CTAC, however, the CTAC arbitration rules is quite unique because there are a lot of arbitrations that use this method of Arb-Med-Arb. And in the CTAC method, so in both, in in the SEAC, in the in the IIAM and HKIC. The difference is that you have to commence arbitration. That is, the arbitral tribunal is formed at first. You get a request for arbitration, then you have the parties commencing the arbitration. After that, you have the arbitral tribunal formed, and the arbitration is stayed immediately after that for the parties to go and settle their dispute through mediation. Now, if mediation does not work, then the same arbitral tribunal that was formed will come back. They would take the matter into their hands, and they would arbitrate the matter. They would come to an award eventually. So mediation did not work, then you go to arbitration. So this is an Arb-Med-Arb. However, with CTAC, while I was working, my experience was that arbitration would have started, the tribunal would have probably formed, and pleadings would have eventually been continued as well. So you would have the statement of claim and the statement of defense, and you'd even have a hearing at times. And it is after then that the tribunal asks the parties whether they would want to settle the dispute through mediation, because this arbitration is probably going nowhere. And if the parties agree, then they go into mediation. And more often than not, the arbitral tribunal is becomes the mediator. So if it's a 3-member tribunal, all 3 of them become mediators. And if it's probably a sole arbitrator, the sole arbitrator becomes the mediator. So this is switching of hats. So from arbitrator, you become mediator. And if mediation does not work as well, then again, they change their hat, become an arbitrator or arbitrators, and then they would resume the arbitration from where it stopped previously. And so this is a proper example of Arb-Med-Arb, and this originated mostly from China. So it's more of a cultural thing. And yeah, so I think I've given a bit of context. I hope I answered to the question based on that.
All right, sir. So my doubt is, there's an inherent doubt that usually you use either Med-Arb clause or Arb-Med clause. It's just one tiered clause, right? So why do we have Arb-Med-Arb? Like, why parties usually choose for Arb-Med-Arb clause?
So if you look at it, parties generally choose a Med-Arb. They are more likely to choose Med-Arb rather than Arb-Med-Arb. And Arb-Med also very rarely. It's only if they want a long relationship after arbitration, they would want to mediate this agreement. Why they would choose an Arb-Med-Arb process? So like I mentioned, so you already first thing is that you have an arbitral tribunal already formed before the mediation started. Now, if the mediation does not work, you don't have to appoint another tribunal to resolve the dispute. You already have a tribunal that is constituted, and the same tribunal can be used afterwards. So to avoid further cost, to avoid further complications and further procedure to appoint another tribunal and to make it more time efficient, you can just use Arb-Med-Arb. The second thing that I've seen at CTAC is during arbitration. So when you directly go to mediation, sometimes the parties do not know what the real issue is. They might not know each other, firstly, and they do not know each other. It's probably just seeing each other for the first time. And sometimes, so what happens is they can't really get into deep as to what the issue is. So then they start with arbitration, where a lot of issues are already formed. So you have the tribunal that forms the issues for the parties, or the parties deciding on what issues have to be dealt with. And once you have those issues, eventually when you go to mediation, you know what issues have to be looked into.
Right.
So that's when parties, they can have more clarity when they go to mediation. So that's when they choose Arb-Med-Arb, or they could choose Arb-Med. And yeah, I think those are the scenarios where parties would rather choose Arb-Med-Arb than Med-Arb.
Yeah, but like Arb-Med-Arb isn't it a rather tedious process that it stretches on your simple arbitration and your mediation? It stretches on, it has cost implications as well. So how feasible it is for a party to offer Arb-Med-Arb instead of a simple arbitration or like a Med-Arb clause, basically?
So cost-wise, again, it depends, I would say. But my personal experience is that Arb-Med-Arb process is is cost efficient. It's more cost efficient than a complete arbitration being done, because one of the reasons is that if at all mediation does work, and generally what happens, so while I was at CTAC, so there were 300 cases per year that were done with Arb-Med-Arb. And these cases finished off within 3 or 4 months. That was like average.
Okay.
So this not only was time efficient, it was also cost efficient because it finished quickly. What happens is that once you get into mediation and you have a flexible process, you can settle the dispute during mediation, and then you can have a consent award, which sort of acts as an arbitral award, which can be enforced as well. And you don't have to go through the entire process of arbitration again. And sometimes you go into mediation even before the hearing takes place. So you don't have to pay for the arbitrator's accommodation. You don't have to pay for their travel to come for the hearing. You don't have to pay for your counsel's accommodation and travel. So, and mediation just happens probably. In fact, there were virtual mediations that happened. And that sort of worked, and it was more cost efficient. So I've seen it being more cost efficient than arbitration, but I particularly cannot say that whether it's more cost efficient than a Med-Arb. Because if you can settle your dispute through mediation before you go into arbitration, definitely it's more cost efficient. And on the other side, if you have a complete arbitration and you have an award and then you go for mediation, or if you have a complete arbitration and hearings, all of that, and you know that this arbitration is going nowhere and you have a mediation, then it would also be costly. So, yeah, Arb-Med-Arb is more cost effective than arbitration, and I don't think it is feasible as well. It's not as expensive and costly as a normal international commercial arbitration or an investment arbitration.
So, sir, in arbitration clauses, as we discussed, that you set a procedure that you filter out that first will be going for arbitration, then mediation, and then arbitration. So, at any point of time, is it a possibility for the parties to opt out of a particular step, or maybe like they might not want to go into mediation but continue with arbitration or something along the lines? Can this combination be changed at a later point of time?
So thank you for the question. It's a very good question. And at the outset itself, I did mention how party autonomy plays a very important role. So party agreement. So if the parties agree at a later stage that they would want to change the process in which they earlier decided in the clause, then of course they can do so. So it's not a problem, because at the end of the day, the tribunal would probably comply with what the parties agree. And if once the parties agree to a particular procedure, and if the arbitral tribunal or even if the court does not comply with it or does not respect it, then it could be a ground for challenge. So yeah, so that way parties can do it. But what happens now? What happens if one party does not want to do it? So say you have a dispute resolution clause, a multi-tiered clause, where there is a precondition that you need to go through mediation first, and it's only after that you go to arbitration. That is, if you haven't resolved the dispute through mediation, you then start an arbitration. Now it is, so in India, okay, I can start with India. It's a bit of a muddy water in India. It's not a very clear position. I know there is a case by the Supreme Court. It's called starts with a D. I'm sorry. It's where the Supreme Court. It's something called distilleries. I've written it down. It's where the Supreme Court has held that so they would look into the factual basis. So if there are correspondence between the parties, and if it is seen prima facie that the parties would have never come into a settlement if they would have negotiated or mediated the matter, then it just becomes an empty formality to have a mediation or a negotiation before an arbitration. And at such a time, you don't have to comply with the preconditions before going to arbitration. So the Supreme Court held that. There are, of course, other cases where the Delhi High Court has held that it's more of a directory requirement rather than a mandatory requirement. And you have the Bombay High Court also having the same view. Now, even outside India, you have UK holding that. I'm not sure if you know the Sulamerica case, because the Sulamerica case is very popular for to determine what law governs the arbitration clause. So it's one of the landmark cases and used in mostly all common law jurisdictions. But not many know that the Sulamerica case also dealt with such a scenario where there was that is whether a precondition that you have to mediate before going to arbitration is required. And the Court of Appeal in that case held that no, it's not a requirement and you cannot. So, but that said, so this is UK, is the same with Singapore as well. Singapore is more mandatory. Yeah. So Singapore, they have held that it is mandatory and it is binding, that it's, the preconditions are binding on the parties. And you would probably have, if you have clearly mentioned it in your multi-tier clause that you would go for mediation first and then arbitration, then you need to finish mediation and then come to arbitration. So, and the courts have held it can be, it can qualify as a challenge to the jurisdiction. So that's where the problem arises. I have also administered cases where the respondent, so you would have a multi-tier clause, or rather a very badly drafted clause where it's not very sure whether it's a multi-tier clause, but then there is somewhere mentioned that mediation, so parties should try mediation first and then go for arbitration. And the respondent would raise a challenge against the jurisdiction of the tribunal, stating that we never went to mediation before coming to arbitration. So there was, the precondition was not satisfied. Hence, the arbitral tribunal has no jurisdiction to look into the matter or start an arbitration. So once a party does that, it qualifies as a challenge against the jurisdiction. And more often than not, tribunals would probably hold that unless they find the clause very ambiguous, and they would hold that, yes, we do not have jurisdiction, go for mediation first and then come to us or from another tribunal. So yeah, so if parties have agreed specifically, clearly that they want multi-tiered mechanisms to resolve the dispute, that probably has to be complied with to avoid any issues afterwards.
So, sir, basically speaking of badly drafted arbitration clauses, so you said that if it's not mentioned in the arbitration clause and if it's mentioned somewhere else, that mediation might be involved. So it is a possibility. What does the court see before, if you could clarify, what does the court see to ensure, to adjudge whether mediation was planned by them, whether mediation was made compulsory by them, or do the court see the intention of the parties before adjudging whether mediation was a part of this whole dispute resolution or not?
Yes. I think it would, firstly, it's like, now you said it's a badly drafted agreement or a clause.
Yeah.
So it's ambiguous because first the courts would generally look at the dispute resolution clause or the arbitration agreement to see whether what the parties have specifically mentioned or expressly mentioned in their clause to figure out the intention of the parties. Of course, now how they're going to look into whether parties had to go for mediation would be based on correspondence. Previous correspondences, how parties had come to the conclusion of the agreement or the dispute resolution clause. I'm guessing a lot of them who participate in the WISMOOT would know how it works, where prior correspondence and prior communication among parties can determine what the intention of the parties are, and intention of the party is. And that's where the court also comes. So they would look into previous. So that's where they would have to. So it's better not to have an ambiguous clause in the first place, because then the parties have to probably do a de novo look. So de novo is probably from the start itself. Yeah. So there's something called a de novo. And so the courts probably would have to start from the beginning, look into the correspondence, something that the arbitral tribunal would have already looked into to find out what the party's main intention was. When it came to whether they wanted to go for mediation first and then arbitration, or whether it was okay for them to just initiate an arbitration without really complying with the requirement of going into mediation. So it is case by case. It depends on what evidence is eventually admitted and what evidence is produced before the court or before the arbitral tribunal. Yeah, I think that pretty much sums up. And I think courts would also look into the statutory requirements. So one thing, like I mentioned, in Hong Kong, because of the Practice Direction 31, which sort of mandates that parties go for mediation before they go to the court. So then the court would probably say, would claim or state that it would have been better that you had gone to mediation rather than arbitration, and then come to us. Because you did so, probably you would have adverse costs orders against you. And so yeah, it also depends on the what's provided in the statutes and what the position is in a particular jurisdiction.
Right. So another question that I had was basically, there are certain issues that you can only arbitrate upon, and there are certain issues which you can solve through mediation. So is it allowed in Arb-Med-Arb to sever the issues itself and set certain issues only for arbitration and certain for only mediation?
Yes. So again, I'm going to rely on party autonomy. So if the parties decide, otherwise, even if the tribunal, if they know that they would be mediating the dispute afterwards, they can have certain issues dealt in during the arbitration and have certain dealt during the mediation. But generally, the position is that you would have the issues in arbitration. So during the arbitration in itself set off, like it's only the issues that are dealt during the arbitration that are dealt in the mediation. They do not bifurcate it because it's the same dispute. It's going to be the same issues. And it's not like there are some issues that would be that only arbitration exclusively can deal with and not mediation.
Okay.
So yeah, it's probably rare. From my experience, I've seen it is rare that they bifurcate the issues between arbitration and mediation. However, there are concerns as to where, if at all you're dealing with some issues during mediation, whether you can deal with the same issues when you resume arbitration in an Arb-Med-Arb process. I mean, there are different schools of thoughts about it. There's this concern for impartiality of the arbitrator who has dealt with confidential matters regarding a particular issue and has known more about the parties, got more information from the parties, probably in a private session or during a group session. And which they thought would be confidential, and they made a frank disclosure of it, but would prejudice them, even though what they disclosed would not be used in the subsequent arbitration that would resume, or the arbitration that would resume. They would always be this bias. They could be. Well, there's this concern of biasness of the arbitrator who was previously mediated when he switched hats, because he knows about it, and
right.
There could be it could affect his judgment, it could affect his impartiality. So yeah, and probably that's something I'll discuss during the course of this discussion as well afterwards.
So that was another point that it came to mind, that, why to have the same arbitrator, like the same set of arbitrators for arbitration and the second arbitration that is going to happen. Because again, the issues have already been dealt in the first arbitration. Like that issue itself has been dealt, and sort of a final result has come with it. Award has if not an award, at least they have come to a conclusion regarding that issue. So bringing that issue again in the second arbitration, what difference would mediation make in between?
Okay, so yeah, yes. I think one thing that needs to be understood is that if a conclusion is reached in an arbitration, there's no point in going to mediation after that. If
right.
there is an award, if there is a finality and an award and there is no real issue between the parties, or there's no particular issue with respect to having the disputes resolved through arbitration, then there might not be a requirement to go to mediation. That said, though, there is this particular process that happens where the arbitration goes on, it finishes, and the arbitrator, he would seal the award. So he would draft the award, he would decide as to who is which side won, and he would put it in an envelope and seal it, and would not tell his or her decision to the parties, and would ask the parties, let's go to mediation and see if you can settle a dispute rather than as an arbitrator, me giving you an award and you would have to probably pay like huge damages. One side would have to pay huge damages to another. Rather make it a win-win situation where probably both sides can come to a compromise, and there's not much, it's not a burden, it's not a cost burden for either party. So there's this, so it happens. And so it happens generally when arbitrators or even parties, arbitrators know that the parties would prefer a long relationship.
Right.
You wouldn't want parties to eventually come into a dispute just because of an award that was passed by an arbitrator. And you would rather want a mediation where both parties would want to have an amicable settlement and have their relationship last longer. And that's when it comes into the picture. Now, having a second arbitration after that, that's not needed now, right? Because you already have a sealed award. And if the mediation does not work, then the arbitrator can eventually disclose the award, disclose his decision to the party, saying that party A won and party B lost. So you don't need a second arbitration to again go through the same issues and matters once again. Anjali, I think there's a connection issue between.
Yeah. So my question, so as you explained that arbitration, you don't necessarily need to go for a second arbitration. So, sir, can this second arbitration be used by the party who has lost, let's say, to raise those issues again, which has already been settled in the first arbitration? Maybe like something like an appeal, probably.
Well, if it's the same arbitral tribunal, I think the issues would not be taken again. The tribunal already knows the issue. They know what the issues are. The parties know what the issues are. So it doesn't become practical to again argue on the same issues. Obviously, it depends on which stage the arbitration had reached before mediation went, or before they proceeded to mediation. Because if it had reached the pleadings had closed, and so there's a stage where so you would have the pleading stage where the parties would have the statement of claim, the statement of defense, the reply, the rejoinder, all of that submitted, exchanged among themselves through the tribunal. And at a stage, the tribunal would declare that the pleading stage is closed. So this is a closure. I wouldn't be taking any more arguments, any more pleadings. Let's move to the hearings. And already issues have been framed by then. Now, if that stage has already been reached in the first arbitration, I'm not going to say first arbitration and second arbitration, previously in the arbitration, because it's pretty much the same arbitration that happens afterwards as well. You can't really label it as a second arbitration. So when arbitration resumes, once mediation is not successful, then, and if the pleadings have already been closed, so the arbitral tribunal has declared that the pleadings to be closed, then he wouldn't look into the same issues and pleadings once again. He would go back to the same pleadings that were submitted previously in the arbitration and then come to a decision. So it's not a point. Now, that might, however, change if you have an Arb-Med-Arb where you have one tribunal that has been constituted for the arbitration, and you have mediation. So you have to, you stay the proceedings in the arbitration, or you go to mediation after the arbitral tribunal is formed, and you form another arbitral tribunal after mediation to resolve the matter, because there are times when the arbitral tribunal or the arbitrators are functus officio. That means they are relieved of their duties before the mediation, where the parties say that we don't want to go do arbitration anymore. So the parties can decide, we do not want arbitration anymore. We can settle our dispute through mediation, and we sort of the jurisdiction that we provided to the tribunal, we are going to take it back. So, and then they start mediation. And then if mediation does not work, they start with arbitration again. That is when you can call it a second arbitration. And they have to probably go through the same issues once again, because the previous arbitration is confidential generally, and you cannot use it in the second arbitration. Well, that's another issue. I mean, if it's between the same parties, of course you can, but otherwise that probably can be an issue that can be raised at a second arbitration.
Right. So we were discussing statutory mandate, statutes mandate, arbitration or conciliation and like before arbitration. So similar is the situation in Arbitration Act of 1996 itself, where the tribunal can ask the parties to go for conciliation. If they seem that it is more feasible than going for arbitration, and even the courts can do it. So, sir, in that situation, does an Arb-Med-Arb clause, is it really necessary to be inculcated in the arbitration agreement? It becomes redundant at that point when the tribunal itself is asking the parties to go for conciliation. So
it does become redundant. So you don't need it. And in fact, if the parties have not agreed it in their clause, and if the tribunal says that, yes, this is the statutory provision, let's try it. Since you haven't agreed, that is, the parties haven't agreed that we have an Arb-Med-Arb process, but since it's mentioned in the legislation, go for conciliation and then come to us. So in that case, of course, it becomes quite redundant. I mean, it doesn't become redundant, but at least there's more specificity. If there is an Arb-Med-Arb mentioned in their clause, at least the tribunal prima facie knows that they would probably have no jurisdiction unless probably mediation had to go. They had to probably conduct a mediation prior, or at least there's some specificity as to the tribunal that they would want to act as mediators at a later stage. So yeah, and so that's one thing I wanted to just clarify at the beginning as well. So multi-tiered clauses per se would not probably qualify as Arb-Med-Arb. So multi-tiered clauses are different. It's just tire-wise, and Arb-Med-Arb is generally when the same arbitrator or the same arbitral tribunal acts as the mediator and again acts as the arbitrator. So that's the classic example of an Arb-Med-Arb. So yeah, so then what you would be probably mentioning is more of a multi-tiered clause where there is a precondition that you first go to mediation and then come to arbitration. But if they have not mentioned so, then at least the legislation mentions so they could do so.
All right. So if we have to talk about the disadvantages of having Arb-Med-Arb clause, so are there any disadvantages specific that people should be aware before going forward?
Yeah. So okay, one thing I would like to say. So the Western countries are a bit averse to the Arb-Med-Arb. Not only Western countries, a lot of common law jurisdictions are a bit averse to a Arb-Med-Arb process. Now, this is because there are two schools of thought when it comes to Arb-Med-Arb. So what I'll do is I'll just tell you, I'll probably tell you the benefits and the disadvantages as well. So both can be covered.
Yeah.
So the first school of thought is where they support the Arb-Med-Arb process. And so they just say, so one first advantage that they would say is that it enhances the long relationship that the parties had, because you would go to mediation and you would not have a contentious attitude when you go to mediation after arbitration, and you can settle the dispute amicably. So that's the first thing. Second thing, like I previously mentioned, it's more cost efficient sometimes. So because you settle the dispute soon after the arbitration, and you would probably not have to go through the entire all the stages of arbitration or the entire process of arbitration. So it saves cost and time. So that's the second one. Third is they mention that the mediator, once the arbitral tribunal becomes a mediator, he has a better idea of the case while he or she was an arbitrator, and because of which mediation would be a lot more smoother process. So that's when you can actually come to a settlement, because you have the issues in hand, you know what issues to deal with, and then you ask parties relevant questions as to what has to be done. And so these are the benefits that the ones who support Arb-Med-Arb state. Now, the other school of thought is so it's the one which does not support Arb-Med-Arb. And some of the reasons why they provide so is, like I first mentioned, is the conflict of interest issue. So once an arbitrator becomes a mediator, in a mediator, in the mediation process as a mediator, you sort of become like a facilitator, and you hear the parties disclosing everything because the parties trust you as a mediator, so they need a frank opinion. Now, once you are a mediator and you get to know all of this, of course, there will be some bias because you have heard some confidential details which are personal to some parties. And then you go to arbitration, and that might affect your judgment. So this is conflict of interest. In fact, the IBA guidelines on conflict of interest, one particular guideline which particularly states that if the parties have not consented to it, no arbitrator should try to conciliate or mediate a dispute afterwards, because there is an issue of conflict of interest. And this is more to do with impartiality rather than independence. So generally, both terms are interchangeably used. But one thing that needs to be noted is impartiality is more of a subjective thing. It's more cognitive. So I could be biased to someone just because I'm related to someone. So that's more impartiality. Independence is more objective. It's like you can prove that independence of an arbitrator, that the arbitrator is not independent based on certain factors. So probably he or she has written an article about something of one of his views, or there is some corruption that happened or something. So it's more objective. So you can actually prove independence, but it's very difficult to prove impartiality. So so there is this concern that arbitrators will be more biased after they switch their hats from mediators to arbitrators. So that's the first concern. Second concern is that not every arbitrator would have the skill as a mediator.
Yeah.
So once you are an arbitrator, you are dealing with contentious matter. You may only know how to reason, probably provide reasons as to who is a winner and who is a loser. But as a mediator, you need proper soft skills. You need to know how to communicate with parties. And in fact, there are various training programs that are done just for mediation, how to become a mediator, how to be an accredited mediator. And they just teach you soft skills, how to listen to parties, listening skills, communicating skills, how to speak, how to gain trust among parties. So that's one. So that's the second thing that they are concerned about. Third thing is that when you are an arbitrator, you have this mindset already that you have to come to a decision. And when you go into mediation, you are not supposed to provide any solutions to the parties, and you're not supposed to come to any decision. You need to let the parties come to their own solution and decision so that they can amicably settle their dispute. So it doesn't work in Arb-Med-Arb. So there's this concern by a lot of common law practitioners that this wouldn't work. And so these are the concerns, these are the disadvantages of Arb-Med-Arb, and also the benefits of Arb-Med-Arb. Again, it all depends on what the parties want. So one thing is party autonomy. I think almost all the sets of arbitration rules clearly specify that unless otherwise agreed by the parties, or unless it is expressly mentioned by the parties cannot, the tribunal cannot have mediation or conciliation after an arbitration. I hope I answers your question.
Yeah, right. So with this, we would like to end our session. It's been great having you with us today. So I hope we could contact you later on with any other questions that the participants might have.
Yes, I mean, I would be more
Anjali, I have a... Hello?
Go ahead. Yeah.
Hello?
Yeah, Prince, go ahead.
Yeah. So Anjali, I have a question to Madhav, sir. So, sir, as you said in Arb-Med-Arb, in a general Arb-Med-Arb clause, the parties usually resort to arbitration and then the proceedings are stayed, and then they refer to mediation. So, And in a Med-Arb clause, we start with the mediation. So I don't really get the need of starting with the arbitration and then shifting to mediation when anyway the proceedings are to be stayed. And then, mediation has to be, yeah.
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 So yes, thanks, Prince. That's quite. So I think I previously mentioned. So one of the reasons why you would have an Arb-Med-Arb, and especially at the time when an arbitration is stayed to go into mediation, is you have the arbitral tribunal already formed. So you don't have to form an arbitral tribunal afterwards. You start with arbitration, you have the arbitral tribunal formed, it's commenced, and then they stay the proceedings. Then you try mediation, and if it does not work, you have the same arbitral tribunal that was constituted previously deal with the matter afterwards. You don't have to go through this entire procedure again to appoint an arbitrator. And when you have a mediation, so when you have a multi-tier clause where you would have a Med-Arb, you would probably have a different mediator. And after that, you would have to, if the mediation does not go well, you have to appoint an arbitrator. So I think it's more to do with specificity. And it's basically party preference, if they want it or not. There's no hard and fast rule that they should probably go for Arb-Med-Arb or Med-Arb. If they find it more flexible to do a Med-Arb, then might as well do so. But if they think it's more useful to do a Arb-Med-Arb, then they can decide to do so.
All right, sir. All right. So just one more thing. It's in a hypothetical situation. So let's say in a general scenario, the arbitration proceedings will be stayed and then the matter will be referred to the mediation. However, can it be like that? The parties refer to arbitration, the questions are determined, even the arbitration proceedings are held. However, then one of the parties thinks that so basically what I mean is, can this mediation stage be shifted to a later date? As in the proceedings are not stayed and after a later stage, the parties refer to mediation. Can it happen?
Yes. So that's what I also mentioned. So at CTAC, where I used to work previously, it was generally the case that arbitration used to proceed to a particular stage, even sometimes through the hearing stage or even the pleading stage. And after when the arbitrator or the arbitral tribunal would probably suggest to the parties, why don't you try conciliating the matter or going to mediation and amicably settling the matter. And the parties, if they agree, then they go into mediation. And even if the parties agree midway, one of the parties say that let's go into mediation because this arbitration is not going anywhere, then definitely the arbitration can be stayed there with the parties' agreement. If the parties agree that the arbitration has to be stayed for them to mediate, then of course the tribunal has to comply with the parties' agreement, stay the arbitration proceedings, and let them go for mediation and see if they can settle their dispute in mediation afterwards.
All right, sir. All right. Thank you so much.
No problem.
If anyone else has any questions for Sir, please unmute yourself and you can go ahead and ask him.
Hello.
Yeah.
Yeah, I'm Thomas.
You're audible.
Yeah.
Yes, Thomas.
Yeah.
Yes, Thomas. Tell me.
I had a question regarding without prejudice clause in general.
Yes.
When you have a liability that any confidential information revealed cannot be used in future litigation, is it on that ground that just because mediation has that revelation of the confidential information, I cannot even claim it on proof of that particular information? For example, in the example which you have given regarding the Motor Vehicle Act, that you were texting and driving. So definitely I cannot raise the point that since you have spoken in the mediation that I have been texting, and my liability would be something else, like I would be liable. But can I prove on some kind of evidence that yes, you were indeed texting?
Yeah, a very good question, and rightly pointed out. So if the statement that I mentioned, so just disclosure that I had that I made while during the mediation cannot be used against me. So that cannot be used as an evidence, saying that it was more like a confession. So Anjali cannot say that because sometimes mediators write notes and there are minutes written. And so Anjali cannot go and state that the mediator has written down that Madhav did say that he was negligent in driving, and because of which the accident happened. That said, so she can't say that to the court and the court cannot admit that. That said, if there are other evidence or documents that suggest that, yes, I was negligent in my driving, I was texting and driving, and you produce that to the court, that will be admissible because you're proving my negligence in the court and that evidence. And in mediation, you do not really use evidence. So you do not, it's very rare that you see parties providing evidence to the mediator saying, no, this person was wrong because of him. And this is the evidence that the accident happened. And this is the evidence that shows it's because of him, because the mediator cannot adjudicate on the matter. However, in litigation, the court can adjudicate on the matter on the evidence that you provide. So if you subsequently find evidence and documents that can prove that I was negligent in my driving, of course you can use that, but you cannot go to the court and state that he mentioned so in the mediation that he was negligent in his driving and hence he is liable for the accident and not me. The court would, so the without prejudice rule basically states that the court would not admit that statement that you made in the court.
All right. Thank you.
No problem. Yeah, and feel free to ask me questions. I would be more than happy to answer. In fact, even before the session, I told Anjali I would rather wanted a more interactive session than me just talking. But I guess either I was too clear on what I said, or maybe I wasn't too clear and not many knew what to ask.
Guys, please go ahead and unmute yourself. And if you have any questions. All right, so I don't think we have any other questions with the audience. So it was great having you. It was great talking to you all through this 1 hour. I think it was a very enlightening and interesting session. At least we learned about something which we haven't discussed much upon earlier. In fact, most of us have been new to this whole concept of Arb-Med-Arb. It was great having you and for you to give your valuable time and opinion on this. So,
I mean, sorry, no, I was just saying it was a pleasure. I mean, it was a pleasure. And in fact, I too enjoyed talking about this, talking to you about this, and also sharing it with whoever participated today. I really hope it was helpful though, to all of them.
It certainly was, sir. So we've recorded this session and we'll share it on YouTube on our university's platform, and also with you for like if you would like to share it ahead. So with this, we come to the conclusion of today's session. I hope we can come in touch with you later for any other questions or doubts that we have.
Definitely. In fact, if either of them would want my email address, you can share it with them. I am also generally active on LinkedIn. So if either of you want to connect with me, you can connect and ask me questions on LinkedIn. So I'm more than happy to just